Hello.
Hello and welcome to Hotel Investor Marketplace, produced by Hotel Brokers International. I'm Tony DeGeorge, President of HBI and President of Green Canfield DeGeorge, a hotel brokerage consulting company located in Clearwater, Florida. The Hotel Investor Marketplace was designed to provide the most current information in franchising, lending, valuation, as well as provide an opportunity to preview some of our current listings. While everyone's getting settled in and comfortable, we will highlight a few of our HBI member listings on the screen as you see those. And if anyone would like to see some additional listings, certainly always go to our website, hbihotels.com. Hotel Brokers International was founded in 1959 and is a leading hotel sales organization with membership of more than 50 hotel broker specialists. HBI members have successfully negotiated more than 10,000 hotel real estate transactions and annually account for approximately 48% of the mid-market and economy hotel sales in the U.S. Again, please visit HBI on our website, hbihotels.com, so it's hbihotels.com. We do welcome questions during the webcast. Just click on the Ask a Question button found on the gray bar located at the top of the webcast player. Type in your questions and submit them. We'll answer as many as time will allow. Let us know also how we're doing. Rate our webcast by clicking on the rate, which is also found in the gray bar located at the top of the web player. Today's webcast will be posted also on demand viewing on our HBI website. This time I'd like to take the opportunity to make some introductions. Our first person that I'd like to introduce will be Joe Kennedy. Joe Kennedy is president of Crystal Investment Properties, LLC, a full-service hotel brokerage and consulting firm located in Portland, Oregon. A 30-year hospitality industry veteran, Joe is also a member of Hotel Brokers International. Joe and I are also visited today with attorneys Joseph A. Field and Richard M. Saltzman. Joe Field with Field Jerger LLP located in Portland, Oregon. He is an active litigating and bankruptcy attorney. Prior to practicing law, Joe worked in the investment banking division of Morgan Stanley International and for Merrill Lynch Capital Markets. His technical financial background is valuable in litigating matters involved in financial fraud, distressed assets, complex debt, and credited issues in reconstruction. Today he will be talking to us about resolution strategies to get ahead of the curve of foreclosures. Richard Saltzman is with Richard Saltzman and Giambrone, a Saltzman LLC located in Fairfield, New Jersey. Richard is experienced in both private practice and corporate in-house counsel and has served as senior executive with Wyndham Hotel Worldwide, where he was responsible for franchise administration for all of the Wyndham Hotel brands, as well as the RCI Holiday Network. As corporate counsel, Richard handled all aspects of support for franchise sales and administration departments in contract negotiations and oversight of the franchise compliance functions. Today, Richard will be with us in talking about franchise agreements and contract negotiations. To open our webcast, I'd like to have Joe Fields give us an idea, of some of the things we'll be talking about. He also has some slides, I believe, that will be coming up on our website also.
So hello, I'm Joe Field. I'm an attorney in Portland, Oregon, and I work in commercial litigation and bankruptcy cases I represent debtors, that's parties that owe money, and creditors, that's parties that lend money and are owed money. So I work on both sides and get to see the perspectives of clients on both sides. Very specifically, today we're going to talk about what hotel owners can do who get behind in their debts and how bankruptcy can be used as a tool to help hotel owners hold on to their property or hold on to the equity in their property, or to protect themselves on personal guarantees they may have extended on behalf of the companies they own, which own their hotels. And so the first question that comes to mind is, when do you speak to a bankruptcy attorney? And the answer to that question is not at the last minute when everything is going wrong. It's something to do early on. If there are debts at the hotel which you cannot pay back, or where there's a loan coming due, such as a mortgage, and an adequate refinancing does not seem to be available, it's time to go talk to a bankruptcy lawyer. A good bankruptcy lawyer will start out with you and try to determine what are your objectives. And to do that, the lawyer will first need to learn the facts from you. The lawyer will need to know, what is the market value of the hotel? What sort of debts are there encumbering the hotel? What sort of operations does the hotel have? Are the operations efficient? How do they compare to industry standards? For instance, what is the ratio of food and beverage to occupancy? What are the occupancy rates compared to other hotels in the area? What are the occupancy rates compared to other hotels in the same franchise group? How is the franchise relationship? Is it profitable or is it problematic? Is the franchisor requiring more upgrades than makes sense for the local market? Are the franchise fees onerous? Is the franchise not returning enough? Is the franchise not returning enough guests and reservations for the cost of it? What about the local market? Is the market changing? Is the hotel competitive in its market? Sometimes there's overinvestment in a hotel and the market never quite catches up and the hotel just has too much cost to be competitive. Other times a hotel will be wildly profitable, will get a high appraised value, the owners will take money out, lever up the hotel to start other projects, and the market will catch up, and new hotels in the market will leapfrog past the hotel, rendering it obsolete and unable to service its debt. So all of these are factors that the client is going to have to analyze and share with a bankruptcy lawyer in order for the lawyer to be able to give reasonable advice. The next step in the analysis is for the lawyer and the owner of the hotel to discuss what the owner's intentions and objectives are. If there's only one owner, or if there's a corporation, a partnership with one shareholder, then the individual owner and the entity are the same. However, if there are multiple investors in the hotel, the lawyer will have a duty to act on behalf of the ownership group and not on behalf of any individual. And it will be important for the ownership group to get together and to either appoint someone as a representative to deal with the lawyer, or for the lawyer to meet with the entire ownership group and discuss the intentions and make sure that the different investors in the hotel have aligned intentions, or at least that there's a majority rule in accordance with the bylaws of the ownership group, so the attorney can act on the entity's behalf and not on the behalf of any one investor within the entity. The next step in assessing the owner's intentions is to figure out what makes the most sense. One possibility is to reorganize the entity. Another one is to recapitalize, which means bring in new investment money either through equity or debt. Another one is to actually sell the entity. And bankruptcy is a powerful tool that provides tremendous flexibility, but it's also expensive and onerous, and it's extremely important to get organized before availing a party of bankruptcy. You need to have a short-term plan for the pre-bankruptcy stage of organizing and figuring out what the plan is in bankruptcy, and then long-term objectives need to be analyzed, so there's an exit strategy from bankruptcy. For instance, you wouldn't get into an airplane without a flight plan. Before getting into a plane, you'd want to know there's a pilot, you'd want to know the fuel tanks are full, the engines work, you'd want to know what the weather is, where the airplane's going to land, what an alternate airport is, etc. And bankruptcy is just like that, waiting till the last minute with a foreclosure coming, and then filing bankruptcy as a short-term stopgap that's bound to fail. Alternatively, by having an honest assessment of the assets, liabilities, the owner's objectives, market opportunities, and what is feasible and viable can lead to a very successful bankruptcy. The first step in that, after these preliminary steps we've discussed, is analyzing the debts of the entity. Who does the entity owe money to, and what are they thinking? For instance, there could be a hotel with seller financing, and we typically see seller financing when a property won't appraise for a high enough value for traditional financing from a financial institution like a bank. In that case, the seller may want to sell for more than market value, and the seller may take risk and extend a second mortgage or sell the entire hotel on contract. The most failed sales we see are in those scenarios, and the banks are professional lenders. The seller of the hotel is an occasional lender lacking the same expertise in lending as the banks have, and there's a reason that banks have loan-to-value ratios, and when the seller of a hotel exceeds those ratios, that seller is taking risk. And so in analyzing the lender objectives, it may be when a seller sells a hotel on a contract that that party is looking for long-term cash flow and looking for installment sale where they don't pay capital gains taxes all at once, and it may be possible to restructure the debt with that seller. Alternatively, and what we more commonly see, is a bank that's under pressure from the FDIC to get a bad loan off its books, or a bank that bought the loan as part of a package from the FDIC. The FDIC is the Federal Deposit Insurance Corporation. It's a government entity that oversees banks, and when banks get in trouble, the FDIC forces them to sell assets, which means portfolios of loans, and to get more money for the loans than the market will bear, the banks enter into something called stop-loss agreements, or the FDIC enters into stop-loss agreements with the purchasing bank, whereby the acquirer, the buyer of the loan, will pay a higher price, and the FDIC will have an agreement in place with that bank that if there's a loss on the loan, the FDIC will pay a certain percentage of the loss. In those cases, to avail themselves of their stop-loss agreement with the FDIC, the banks are under tremendous pressure to get the loans off their books quickly when they come due, and there's little flexibility in negotiating. We've seen a lot of that over the last year with loans that banks wrote in 2008 with 5-year loans that came due in 2013, where the banks were under huge pressure to get the loans off the books, and the borrowers just couldn't sell their hotels for enough money to pay the loans. And I worked through, I think, 4 Chapter 11 bankruptcy cases with Joe Kennedy arising out of facts that were related to that scenario. So once this preliminary analysis is done, and the lawyer and the owner of the hotel, who's the client, agree on what the objectives are and analyze the debt load of the hotel, the operations, the places where expenses can be trimmed, the short-term and long-term viability of the hotel, analyze who the lenders are, figure out what the lender's objectives are. The next step is to figure out what the owner hopes to achieve in bankruptcy. Does the owner hope to simply get more time to stop a foreclosure to sell the hotel? Does the owner seek to bring in new partners or new lenders to recapitalize the hotel? Does the owner seek to cram down the debt to the bank to actually reduce the amount of the debt and to term the debt out through the bankruptcy reorganization process on more favorable terms? These are all possibilities in bankruptcy. A big issue which comes up in hotel bankruptcies regularly is the issue of personal guarantees, where the hotel is in a single-purpose entity, like a corporation, a limited liability company, and that entity signs the loan documents, but one or more of the owners of the hotel have to sign personal guarantees. And so when the hotel goes into bankruptcy, even if it crams down the loan and pays less than it owes, the bank has recourse against the principals and can go after them. So that's a major consideration, and there are different legal opportunities to use the bankruptcy case to try to get an injunction to protect the individuals, or to dissolve the corporate entity and have the individuals perhaps take on the ownership and debt themselves and to go through a bankruptcy themselves. That's just two examples of many possible opportunities. I'd like to change topics slightly. Given this backdrop, I could go on and on, but it's a complicated subject, and I don't want to give too much detail. My objective is to give a broad overview and then to dive into some demonstrative cases to explain how this works. The first case I'd like to talk about is a case in Eastern Oregon. And for those of you who don't know and who think of Oregon as a state with forests and rainfall, that's true west of the Cascade Mountains, where Portland, Oregon is, where Eugene, Oregon, with the Oregon Ducks football team is. We have forest and rain and supply timber all over the world. But when you go to Eastern Oregon, which is about two-thirds of the state east of the Cascades, we have the same desert that you might think of as existing in Nevada. It's just that we're further north. We have arid scrubland where it typically stops raining sometime in the early spring and doesn't start again till late autumn. And the communities in these areas are resource-based communities. After the economic downturn in 2008, these communities got absolutely devastated. And one of Joe Kennedy from Crystal Investment Properties clients was a hotel that took advantage of the economic boom and really ramped up its operations for food and beverage. And the owners had tremendous personal satisfaction from being the local watering hole and the best restaurant for miles around, being adjacent to a golf course, which was kind of a who's who of the local personalities for a huge geographic area who would come out, play golf, and go to the bar and restaurant. And the hotel was independent and was not visible from a highway, had poor signage, but would do business based on local government contractors in the area, overflow from a nearby city 15 miles away, and based on the local golf resort. The owners of the hotel levered the hotel up with debt so the owners could take advantage of the booming real estate market and become speculators. And as you can imagine, when the market turned south, the hotel revenues weren't there to support the debt. The speculative real estate investments were deep underwater, and there was absolutely no market for rural speculative investment property, and the owners couldn't service the debt. The owners made a bad deal with a special asset representative of the bank, and the owners turned over possession of the bank to the special asset representative of the bank, thinking that the owners had a deal whereby the bank would look after, insure, maintain the hotel pending sale. The owners should have spoke to their broker, Joe Kennedy, in more detail first and should have contacted an attorney. The special asset representative from the bank boarded up the hotel and put signs on the doors that essentially said, condemned premise, stay away. Nobody maintained the hotel property, and needless to say, the hotel was distressed and in an unsaleable condition, and the bank proceeded with a foreclosure. The owners went to Joe Kennedy of Crystal Investment Properties, who came to me. We put the hotel into a Chapter 11 bankruptcy case and sued the bank in the bankruptcy court, and on a fast-track litigation. And after our first evidentiary hearing, where we put on significant evidence of the bank's bad acts, we cut a deal with the bank and regained possession of the hotel, got it cleaned up on a shoestring budget, got it for sale, found a buyer, got the bank and a junior lender to take haircuts on the sale price. The personal guarantors were on the hook, but the deficiency they owed by that time was low enough that they were able to sell some of their speculative property in a distress sale and get themselves out from under the bank debt. And had that not happened, the bank would have taken over the hotel in its foreclosure sale, sold it as a distressed, boarded-up property for way below market, and the owners of the hotel, there was a group of 3, would have been wiped out and would have lost everything. So that's one example of what a bankruptcy can do. The next example I'd like to talk about is a case with...
Joe, not to interrupt you, I think one important point of that, this is Joe Kennedy, was that they did consult with somebody who wasn't a specialist in bankruptcy. And when we were able to get them to listen, to reason, and to really call Joe Field, he was able to do what the other guy hadn't been able to accomplish in months, and immediately get the court to, listen to us. And I think that was the point, somebody who really specializes in that field.
Yeah, and I should take a moment and talk about that. And I think what Joe is saying is, the same way had the owners gone to a general real estate broker who said, yeah, we've done a few hotel deals, that person wouldn't understand industry standards in the hotel industry, wouldn't understand franchising, branding, occupancy, food and beverage, upgrades, hotel financing, and there are a lot of friendly real estate agents and brokers out there, but the same way hotel brokerage is a highly specialized business, bankruptcy law is very, very specialized, and a general practice attorney may be a superb seeing eye dog in all sorts of terrain and would know much more than a client about areas like corporate law, criminal law, divorce law, real estate law, intellectual property law, and I could go on. Once you get into a specialty like franchise law, where we have a specialist who's going to be our next speaker, or bankruptcy law, it's extremely important to get somebody with expertise, and a good general practice lawyer or a general business lawyer can refer you to an attorney who has an expertise in an area like franchise law or bankruptcy law, and that's absolutely critically important. Did I answer your question, Joe?
Yeah, absolutely. I just thought it was important to point out that you just needed a specialist, just like you do in acquisitions of hotel or disposition in bankruptcy. You need a guy who does bankruptcies.
Yeah, and the next 2 demonstratives will be a little briefer. Joe Kennedy had a group of foreign hotel owners who were undoubtedly, based on my experience with them, highly ethical within their own culture, but their cultural differences with America were such that the bank that acquired the loans on their hotel felt that they were highly unethical. I don't think that was the case. I think it was a case of cultural differences, but nonetheless, the bank was on a fast track for foreclosure and litigation against the guarantors on personal debt on two particular hotels on which this bank had cross-collateralized loans. And we put one of the hotels first into a Chapter 11 bankruptcy case. And bankruptcy has a carrot and has a stick, fundamentally. The carrot is what's called the automatic stay. It's an injunction the bankruptcy court issues at the outset of the case, a federal court injunction that stops all creditors worldwide from any action against the debtor and protects all property that the debtor owns. The stick is full disclosure. In bankruptcy, a party must make full disclosures of assets, liabilities, income, expenses, etc. on the bankruptcy schedules they file in court and under oath at a creditors meeting as part of the bankruptcy process. And it's a federal bankruptcy crime for a party to make misrepresentations in the bankruptcy court. So the stick is the full disclosure and transparency. The carrot is, well, there are actually three carrots. One is the automatic stay, this injunction which stops all creditor actions. Two is time to get breathing room and to reorganize. And three, at the end of a successful bankruptcy case, there's a permanent federal court injunction which stops all collection activity from all creditors against the debtor in bankruptcy. So it doesn't protect guarantors of the debt, but the bankruptcy can be used to work out the debts. As part of that process, in the case of the foreign investors where there was bad blood between the investors and the bank, which I write off to cultural differences, once we got into bankruptcy court and made full disclosures and had supporting documents to back up those disclosures, we gained the trust of the bank, and with Joe Kennedy's work, we're able to get the bank to realize that the true market value of the hotel was approximately 25% less than the value the bank had on its books, and that even if the bank foreclosed, it would not be able to achieve the market value it wanted. And with that, we were able to get a sale out of the bankruptcy court free and clear of all liens and encumbrances, and to have a reasonable workout for the foreign investors who personally guaranteed the hotel debt to pay the bank, which we're able to do from the sale of the second hotel. And there's more detail to it than we need to go into today, but that's an example of how bankruptcy took a very broken relationship and fixed it. Very briefly, because my time is about up, the third demonstrative I'd like to talk about is a buyer in bankruptcy and why that buyer needs a bankruptcy lawyer. Joe Kennedy, Crystal Investment Properties, represented a Los Angeles buyer in a $12 million hotel purchase out of Seattle, Washington. The buyer had a local business lawyer, didn't think he needed a bankruptcy lawyer, and got into bankruptcy court where everything sounded like English, but it was actually, to someone who's not a bankruptcy lawyer, a foreign language where there are complicated rules and complicated bankruptcy law and procedures. And Joe brought me in to advise the buyers, and it was a good thing because the buyer ended up getting the hotel at the desired price. However, there were a whole series of debts that were not disclosed in the bankruptcy court, some of which were contingent liabilities, like old employment claims, tax claims, which had not yet been through the full legal process. And we were able to have the buyer, which is normal in bankruptcy, if done correctly, buy the hotel free and clear of all liens and encumbrances. And so when these debts came up after the fact, I showed the creditors the federal court orders, and in this case we had a sneaky buyer who didn't disclose the debts in the bankruptcy case, but nonetheless we had a federal court order from the bankruptcy court that the hotel purchase was free and clear of all liens and encumbrances known or unknown, and the buyer was protected and was able to maintain the hotel at the negotiated purchase price without having to litigate additional issues. Thank you. I think I've used my time, and if anyone has any questions, I'm happy to answer them now, or the slide on the website has my contact information, and please feel free to contact me. Thank you.
And Joe, your slide is up on the website, and we appreciate all that you've talked about today, and I think there's a lot of people that will be in our audience and that will certainly appreciate the advice. I mean, it's very important to go to the professionals that you need for specific reasons, and you know, here's obviously reasons why you want to talk to people that have that. Joe Kennedy, did you have any other questions for Joe Field at this time, or?
Well, I think the only one that comes to mind right off the top of my head as far as sellers are concerned is when they know they're in trouble. I mean, it's obviously before they get an NOD or a notice of default. But Joe, when would you say? I mean, when they've missed one payment, or if they, what stage should they contact someone like you guys?
Yeah, and you know, I'm going to make a medical analogy. If you get a cut, you put a Band-Aid on it. If you miss a payment because the check got lost in the mail, you send another check. If you have cancer, the sooner you get to an oncologist, the better your chance of survival. If you miss a payment because you can't afford to make the payment, or if a lender accelerates your debt because you're missing financial ratios, your financial statements you're supplying under the loan documents show that you're not performing, it's time to get to a professional as soon as possible. And when I say a professional, I mean your team of professionals. You should consult with a professional hotel broker to find out what your options are in the marketplace, what your hotel is worth. They may or may not bring in an appraiser. You should consult with your lawyer to get a referral for a bankruptcy lawyer. Contact me. I can advise around the country, although I'm licensed in Oregon and Washington. I can get admitted in federal courts all over the country, which is what bankruptcy courts are. That's two. And you need to speak to your accountant to make sure you have an excellent handle on your finances. So as soon as you know there's a problem that could turn into something for which you do not have a definitive solution, it's better to spend a little bit of money on your professionals now than to let the problem fester to the point where it may be terminal. So think about that cancer analogy and get to your professionals as soon as possible.
That's very good advice, Joe. Joe Kennedy, any other questions?
Not really. Just a comment on from the buyer side. It was very interesting. I thought the transaction, the latest one we did up in Seattle, is that negotiating that process, and Field did that so well, was protecting the buyer's rights and also kind of uncovering where he was concealing information, where he was not providing the full disclosure. And then in doing that, I think the bank looked favorably upon our position and was able to kind of push it through. And that's just my observation. It was very, very helpful. It was critical. We probably wouldn't have closed the deal without him. So.
That's excellent. And another reason, I mean, you know, to just have the right people in the right places. I mean, you know, here with Green Canfield, we've done some different foreclosures and bank deals, and it's absolutely a must to have people of credibility on your side if you're buying or selling. You know, we've negotiated some short sales and have, you know, absolutely had the bank on our side because of credibility issues that you're so speaking of here. So, you know, another reason for all our viewers today to certainly keep that in mind. I think we'll move to our next guest, which is Richard Saltzman. Richard, it seems there's been some people that have joined and anticipating that they may have not heard that Richard Saltzman is a ex-Wyndham legal counsel, and we have a perfect opportunity to talk to somebody about franchise law and also about franchising. So, Richard, if you'll just give us a little short introduction to yourself, we would appreciate that, and we'll go from there.
Sure, Tony. Thank you. Yes, as Tony said, I spent many years over at Wyndham and its predecessor companies, and then HFS. I was in-house attorney for them for a number of years, and then for about 12 years I was vice president of franchise administration. We handled all aspects of their franchise contract work. After that, left there about 6 years ago, opened up our own law firm, and our focus is on franchising, and specifically almost exclusively hotel franchising. And as with Joe Field, although we're based in New Jersey, Joe's in Oregon, we're in New Jersey. Our practice as well is multi-jurisdictional in nature. We can handle matters all over the country. Also, we also handle matters for franchisors. So we also are on both sides of the table. A lot of work for franchisees, but we also handle work for hotel franchisors as well. So we get to see both ends of the spectrum. With our limited time, what I wanted to try and focus on, mostly in terms of franchising, is how franchising interacts with the sales process, because I would think that a lot of the folks on this call are going to be interested in buying and selling hotels, as are the brokers here. So I think I want to touch primarily on how franchising plays in to the purchase and sale process. As Joe Field mentioned, the important thing here, I think, the common theme is get the franchise company in the loop as soon as possible in your process, whether they're a buyer or seller. In terms of a seller, I think what you can do often with your franchise company is to try and get what's called a broker's PIP. Not all franchise companies are going to do that. Some will, some won't. If you can get that, that's good. What a broker PIP would be a punch list that your franchisor would provide, and that you could then have available to you so that your buyer can see what they may be looking at in terms of holding on to the franchise upon a sale. Big ticket item, and it can often crater a deal, which is the last thing anyone wants to do. And the earlier all parties know what's going to be expected to be performed in terms of the work on property, the better off everybody's going to be, generally. Otherwise, you've got to deal with it.
Richard, not to interrupt you, but those are pretty important things to have, right? I mean, we try to, as always, get those. They sort of give us an insight when a typical question as a broker, we're always asked, well, what is the PIP? Or if it's an experienced buyer, obviously, they truly want to have an idea even before contacting or going further with a deal, and we try to have those included in there. With your experience with Wyndham, obviously, can you say those are pretty accurate? I mean, that I know it's not for the individual that has just come to the table and says, oh well, this is one that was done 4 months ago or 5 months ago, but they tend to hold pretty close to what those PIPs will be for the actual buyer. Is that true?
That's true. That's true. And Tony, as you say, the less time that has elapsed from the preparation of the PIP until you're looking at it, the better. Once a PIP gets to be maybe 6 months, 8 months out, it can get a little stale. Things can happen on property that may affect the PIP. There could be changes in brand standards sometimes that can affect the PIP the longer things go on. So the closer in time to the date of that PIP to when you're looking at it, the more accurate it's going to be. I guess is the best way I can answer that. And those are critical. I mean, those are the biggest ticket items generally when it comes to the franchise aspect of a purchase and sale, are those PIPs. The other thing is, as soon as you know for sure that you're going to be looking at a potential sale, I mean, you're going into due diligence, you want to get moving on your application with your franchise company. You don't want to let that go until the latter part of your due diligence period. these franchise companies don't always move as quickly as you'd like them to. They're sometimes they miss things, sometimes they're busy, sometimes it's a bad time of year, and what can go wrong will go wrong. So you want to get your applications in, get your disclosures from your franchise company as soon as possible after you sign your contract, go into due diligence, and work on getting your approvals from them as soon as you can. Get the agreements from them to review, either yourself or with an attorney, as soon as you can. Start negotiations as soon as you can. You don't want to let things go. It's always good to get as much done ahead of time as possible in that process. Just to backtrack a little bit, I'm going to assume most folks on the call understand what franchising is all about, and that it's a regulated industry. It's regulated by the FTC, Federal Trade Commission, and there's also state regulations. I'm not going to go into a ton of detail. We don't have time, but there's a number of states that also regulate franchising, and certain states require registrations. And so there's a whole number of disclosure requirements that can apply in franchising. The bottom line is, in terms of timing, which everyone is worried about, basically you need 14 days from when you receive a disclosure document, whether that's a CD or electronic disclosure, and there's basically a week, 7-day requirement from when you get an agreement until you can sign a franchise agreement. These are built-in time frames that have to be built into every single deal. Really can't get around them, so you got to factor that into your timing on your deals. In terms of applications, transfer applications, the brands are pretty similar. They're all going to look at the same sorts of things. If it's a transfer situation, they're looking at the applicant. They're looking at the financial ability of the applicant to pay, net worth. They're going to do credit checks. They're going to do background checks, and things of that nature. That takes a little time. So you don't want to, again, let things go too long before getting your application in. In terms of negotiating deals, certain things are negotiable with certain companies, certain are not. That's going to vary company by company. Major points of negotiation are always initial fees, royalties, liquidated damage amounts, windows, protected territories, caps on potential liquidated damages, things of that nature. And you want to raise everything you can. You may not get everything that you want, but you want to try and negotiate. I wouldn't just take the agreement and sign it. I would, whether you do it yourself or whether you do it with counsel or an advisor of some kind, try and negotiate whatever terms you can. It's going to vary company by company.
And Richard, just for a quick question here, I mean, a franchise agreement that the present owner has in their hand, we're asked as brokers a lot of time, I want to see their franchise agreement. It really is not a relevant document to the new person coming in. Is that correct?
For the most part, that's true. I would only caution one thing. There are on occasion, you will have language in the existing franchise agreement that may pertain to a future transfer fee, and so sometimes that's built in to the existing franchise agreement. So if a buyer may want to get a look at that seller's franchise agreement and take a look at the transfer provision, and that may govern what initial fee a franchisor can charge on the sale. Other than that, however, you're correct. Generally, the terms, the seller's terms in a franchise agreement are not generally transferable or assignable to a buyer, and the franchise companies generally won't agree to just the same exact terms that the present licensee may have in their agreement. They may, but they may not, and you can't assume that you can just assign these agreements over. These franchise companies want to sign up new forms of agreements every time they do a sale. They don't want to do an assignment. They want to get you on the new form, the current form, and they want to sign the term, a brand new term. So, you may be halfway through the term of your agreement as a seller. Maybe you have 10 more years to go. The new franchise company is going to want a brand new 20-year term. They're not going to really want to just allow you to have the balance of the term of your seller. So you got to, these things you have to know about. You can build windows in there. You can try and negotiate that, but they're going to want a whole brand new term on the new franchise agreement. Next, I just wanted to touch briefly upon windows. A lot of these franchise agreements for the hotel chains have what's called windows. And windows, it's terminology, but a window is basically a right of a franchisee or a franchisor to terminate agreement without payment of any termination fees, liquidated damages. It's a get-out-of-jail-free card after a certain period of time. And if most of these companies have windows in their agreements built in, some of them are negotiable. The one thing I would say is keep an eye on your windows. If you're an existing hotel owner and you're coming up on a window, you're in your agreement for 5 years and you're coming up and your window notification period is coming up, you may want to consider using that window as an opportunity to possibly go back to your franchise company and renegotiate your terms. It can be done in a nice way, and very few folks do it. But I just think more people should take the opportunity to take a look and see how they're doing. And if they feel they want to try and renegotiate their royalty deal with their company, they can go back to their franchise company and say, look, I'm coming up on my window. What do you want to do to retain me? And see if you can possibly get some concessions from your franchise company so that they can entice you not to use your window. They don't know whether you're going to use your window or not, so it can't hurt. And it's just something I think a lot of hotel owners should look at and not enough do in terms of using their windows with their franchise companies.
That's an excellent point, by the way. I think that a lot of people overlook that. It is absolutely a negotiating tool that you have, maybe for reasons of the market changing, and some people at that time may even want to look at the flag that they have and maybe even move upward or downward, but obviously it's an opportunity to look at that and maybe do some negotiating. Exactly.
And I just want to circle back 1 second on the transferability of franchises. One thing I want to make note of is to keep an eye out for what's called variously comfort letters or three-party agreements. Everyone's dealing with financing on a hotel sale, and what we're seeing more and more on almost every, not every deal, but almost every deal, we're dealing with comfort letters, three-party agreements, basically the same sort of thing, and all that really is a document that a lender is looking for to give them some sort of quote-unquote comfort that if they have to end up taking a hotel back, there's going to be some procedure, process, notification in place whereby they can hold on to the franchise if they have to take that property back from a hotel owner. There's various forms that takes. The different hotel companies have different forms, but that can sometimes delay a deal. Another reason why you want to move quickly to make your application with your franchise company and deal with your lender and make sure that if they're going to need some sort of comfort letter or three-party agreement, that gets surfaced early on in the process and it doesn't come up at the last minute and you're 2 days from closing and all of a sudden you find out that your lender's requiring some sort of comfort letter, your franchise company is not being cooperative, they don't like the form that the lender wants, and then you're having your lender fight with your franchise company, and now your closing gets put off because of that. So you want to try to get in front of that issue as early on in the process as possible so it doesn't hang up your deal. And good brokers will be on top of that. Good brokers will anticipate that and deal with that sort of thing early on in the process to make sure that it's not a last-minute hang-up on a deal. So you want to watch out for comfort letters and the three-party agreements as part of the process. Another thing I want to touch upon is termination of franchise agreements. There are sometimes in sales of properties where a buyer will not want the franchise, the current franchise. That can get very, very tricky. As we all know, these agreements all have what's called liquidated damages, And for those who don't know, liquidated damages is just a formula regarding a termination fee that's payable upon termination of the franchise agreement. Instead of the parties having to figure out what damages might be, the parties agree ahead of time what the amount of damages would be if the agreement terminates early. And if you have a buyer who does not want to keep that flag on the building, the seller is going to have to pay the franchise company liquidated damages, and that can oftentimes be a fairly substantial amount. That needs to be worked out. If that's going to be anticipated ahead of time, then the parties need to understand who's responsible for that payment, and if there's going to be an attempt to negotiate those fees down with the franchise company, again, sooner in the process as you can, get that issue surfaced with your franchise company, either with a representative on your behalf, or if you're going to try it directly, you can, but I would caution it's very difficult to try to do that sort of thing on your own. Franchise companies are all over the map in terms of those liquidated damages and negotiations on termination, and it's a very tricky process to try to deal with that.
And Richard, just to make a note, we have one of our listeners asking, is there like a rule of thumb formula for any of those negotiations that you've seen in the past?
They are all over the map. Different companies will hit you with different positions all the time. Certain brands for certain companies, they will not negotiate one penny. I won't mention who that is, but they're out there. Yeah, there's more than one. But yes, some companies, you're right. They're not going to negotiate at all. Other companies are going to be much more flexible. Other companies, when you have I've had situations I've been asked to negotiate liquidated damages, and we do it all the time. But I always warn clients that there's no guarantee that we're going to be able to succeed. On occasion, you run up against a brand and a market and a hotel that a franchise company won't negotiate one penny on. And I've had those situations, and I've had, clients have been very disappointed, but I've warned them that could happen. But that's the exception. Most of the time, there is some flexibility, and a lot of factors go into those negotiations. Replaceability in the market, how much time is left on the agreement, relationship of the franchisee with the franchise company, are there other deals in the works, can we work out replacement deals? So there's a lot that goes into those types of negotiations with the franchise companies, and there's no set rule of thumb that we can just put our finger on in terms of those negotiations.
On our questions, we're being asked, in the franchise agreement, is there a standard that is typical for a franchise to require for liquidated damages?
Yes. Every franchise company will have its standard formula built into its disclosure document and the franchise agreement in its disclosure document. So there will be that standard formula that they offer every time out. That is oftentimes subject to negotiation as part of the negotiations on the agreement itself on the way in. So oftentimes, you're for instance, it may be a $2,000 a room, $2,000 per guest room might be the standard form liquidated damage amount. The company might agree to reduce that to $1,500 per room, or might agree to reduce that to $1,000 per room during the negotiations on the franchise agreement itself. That can oftentimes be negotiated. Sometimes not. There are some brands that will not negotiate that at all. And also, even after the agreement's signed, and you're facing a potential termination situation, you can even go in and try to negotiate those down, even though the agreement calls for something. So, it's both a negotiation process when you're signing your agreement, and it may also be a negotiation process when you're involved in the termination of your agreement. It can happen at both ends of the spectrum. Yes.
This is Joe Kennedy.
I guess the standard statement is that agreement is really between the present owner, not the future owner. So the man that sells the hotel and leaves is not going to leave that agreement if in that transaction someone else changes the brand. Is that correct?
You're saying the seller is responsible. The seller is responsible for the termination and for the liquidated damages unless the agreement's replaced by a new franchise agreement signed by the buyer, or unless there's a termination agreement that's been agreed to between the parties. And if that's unresolved, that seller is going to end up with a claim from the franchise company, and they'll come after him. They come after everybody. I deal with them all the time, and they do not let up. So they will come after folks for those liquidated damages if you don't address these issues with them, either by way of having a new agreement signed from the buyer, or having a termination agreement executed by the seller and the franchise company.
Yeah, I think that's good advice. You need to really just discuss that up front and make that a part of what you want to do as part of selling the property. Because as brokers, I think Joe and I can both attest to people that thought, well, we'll handle that afterwards. That's okay. I'll take that responsibility. And those people tend to regret those decisions.
Yeah, let me add to that. If there's any potential that there might be a termination of a franchise agreement involved as part of a sale, you want to get ahead of that with your franchise company too. You can request what's called a liquidated damage advisement letter from your franchise company. You should do that if you're thinking there might be even a chance that there might be a termination that you're dealing with on a sale, because you want to know what your number is. You don't want that to be a mystery. Don't assume that you know the number. You can get that number from your franchise company ahead of time. And then you can deal with it. You can try and negotiate down from that number as you move forward, but you want to know what the number is going in. And that's good advice. That's good advice, Tony.
This is Joe Kennedy. I'm sorry. I had just a quick question on another. Would you advise that somebody, say they're a new development and they've got a number of brands they're looking at and they're all interested, is it to their advantage, I'm assuming, to hire someone like you to come in and maybe, have them bidding for that particular property or location? What would you bring to the table on that?
Yeah, I mean, it's not. Sometimes it's useful to have the attorney involved. There are other folks you could bring to the table if you want to get other folks involved who have background in hotel development. That's fine too. In terms of the shopping around for which flag you might want to franchise with, there may be better folks than a lawyer to advise. I mean, I think you guys would be better versed even than I as an attorney to talk about what might be the right brand in a particular market. And there are folks who can help with that. In terms of negotiating the agreement, I would say an attorney is the best person to help negotiate the actual franchise agreement when you get to that point. And to your point, I think it's a very good idea to shop around, and I think it's a very good idea to make sure that each of the folks you talk to know that you're talking with other folks. So, if you're talking to Choice, let them know you're talking to Wyndham. You're talking to Wyndham, let them know you're talking to Choice. Let everybody know you're talking to everybody else. And that can only help you in negotiations with these companies to try to get your best deal, because they will try to make sure they give you your best possible deal to keep the other guy from getting the flag. So yes, that's excellent advice, is to let the other companies know that you're shopping around with other franchise companies. You should definitely do that. The other thing in terms of transfers versus new deals, you're generally always going to get a better deal from your franchise company in terms of your deal. In terms of those companies that do negotiate these things, when you're doing a new deal as opposed to a transfer. A transfer, you're going to get a lot less in terms of flexibility, in terms of your deal points, your terms on your franchise agreement, than when you're dealing with a new deal. A new deal, they're much hungrier to get your business, and they're going to be much more aggressive in their negotiations in terms of fees and other deal points as well. So I just wanted to point that out. Some folks think they can get the same sort of deal they can on a transfer as they can on a sale, and it's just not the case.
In transfers, the fees that are there, they are negotiable, though, right? I mean, in most cases, the fee can be negotiated, especially if someone has multiple properties in that same brand, and they're coming to the market. Has been our experience. Is that also yours?
Yes, that's exactly right. They are negotiable, but they're not quite as negotiable, Tony, as they would be if it's a pure new deal. Most of the companies will work with the buyers on the hotels and do what they can. But again, if it's a brand spanking new deal, and depending, the size of the hotel and the revenue coming in, you're probably going to be looking at a better deal if it's a conversion deal than if it's a transfer deal. But most of the companies will work with the buyers to some degree and negotiate those terms in terms of initial fees, royalties, things of that nature. Yes.
And that sort of makes sense for them. I mean, what they want to do is obviously they'd like to add to their a number of properties in that system, and a new deal brings that to them. And of course, they probably look at that a little friendlier than any other transaction.
They do, and there's leverage. I mean, when you're dealing with a transfer, the key thing on the transfer is that there's leverage. You have a seller who has an existing agreement, and if that agreement terminates upon the sale, well, then they can go after that seller for liquidated damages. So they have leverage in that situation, so they don't have to be as flexible in those transfer situations. When it's a new deal, they don't have that leverage. It's a pure sale, and they don't have any leverage at all. And so it's just a difference in terms of the approach.
Richard, one other thing that is something we, as brokers, always seem to be hit with when going back to the PIPs. When they're done, there seems to be negotiations there. Do you ever get involved in those types of negotiations?
Yes, we do. We do, and absolutely, there can be negotiations on PIPs. Again, depends on the company, depends on the brand. Within the same company, in different brands, there's going to be different levels of flexibility. And it's just going to depend on what the brand is looking at in terms of maintaining standards at that point in time. There may be a push for a certain brand to really try to clean up their standards. We're coming out of 2008 to 2012, 13, where there was more flexibility on PIPs during that period. At least that was my experience. I don't know about you guys, but I mean, I think we saw the brands were somewhat more flexible. I think we're seeing a little bit of tightening on that with some brands, not all, but I think you see somewhat of a tightening with some of the brands on PIPs. But that being said, they are negotiable. They may not be negotiable in terms of what needs to be done oftentimes, but timing can certainly be an issue, and there may be some flexibility in terms of when things need to be done. I mean, you could push things out from 3 months to 6 months, or 6 months to 9 months, or things of that nature. So you do see that sort of thing, and you definitely should raise that as part of your negotiations. Don't just take it, as is. I mean, they can work with you most of the time.
And that's been our experience, or at least here in our company here. We have been a party to some of those negotiations where they've been allowed extra time for, maybe painting of the outside of the building and giving them extra time to do certain things, or, sometimes the standards are changed, at the conferences, and so when they come out of those conferences, we see those new standards being applied to the PIPs, and usually we see that as something that can be negotiated for time.
Exactly.
If it's your experience, that would be good to know also.
Yep, exactly right. That's exactly right.
Joe Kennedy, do you have any questions you'd like to submit?
Well, the only one that comes to mind is the conversion from independent to a franchise. How effective is it to bring in counsel to do your negotiating for you in that instance? And we've got a lot of older properties in our area that want to be branded. I just sold a portfolio up in Seattle that was a regional brand, and they had a lot of trouble getting these properties branded. to the standards. And I'm wondering, I think it might have been a help to have counsel involved in that. And I don't know if you guys do a lot of that in your area, though.
Yeah, we do. I mean, we do. I mean, again, you know, we will handle both conversion from brand to brand and from independent to brand. I just had someone contact me today to help them with that. No, the same issues exist in that situation as with any other situation. You're gonna be working on negotiated deal points. You're gonna be working on negotiating the fees. You know, it's not just the fees. There's other issues. There's protected territory negotiations. There's as you mentioned, there's the negotiation on the PIP itself. There's negotiation on windows. There's negotiation on capping liquidated damages. Potential negotiation on future transfer fees. There's a lot of other things that go into the agreement that we help with, and we also, you know, help with folks to make sure that they're doing the right thing, because it may not make sense for them to make the move. And I have talked people out of franchising because it may not be right for them. And you know, I think we do a disservice if as an attorney, if we don't answer those questions and get into those questions. You know, I ask the question, why are you franchising? What are you doing here? What are your numbers? What are you looking to get out of this? And make sure that it makes sense for them. They need to really think hard about it, because independent properties can make it in this day and age, and maybe it's right for them to be an independent. Not everybody needs to have a franchise. It can help with people, it can help with hotels, but maybe not with everybody. And so we have those conversations with clients as well, and sometimes it goes the other way. So.
Yeah.
Excellent.
Yeah.
Well, and sort of wrapping things up, is there anything that Joe Kennedy you'd like to add, or Joe Field or Richard?
I had a question. I had a question for Joe Field. Joe, you still there? I don't know if Joe's still
Yes, I am.
Joe, just a quick question. This kind of touches on both our worlds, I want to again say what Joe said. You want to deal with an expert or someone who specializes. You don't want to you want to make sure the people you go to are very familiar with what they're talking about. So, but I'm going to ask Joe a question about franchise agreements in bankruptcy. If you could just touch on briefly how franchise agreements are handled in bankruptcy in terms of acceptance and rejection. Just you know, a couple of seconds about how that works.
My pleasure. Thank you. Good question.
Sure.
In bankruptcy, the debtor, the party filing the bankruptcy, is required to disclose all executory contracts and unexpired leases. An executory contract is a contract where one party still has a duty to perform. So a franchise agreement would be viewed in the bankruptcy court as an executory contract, and the bankrupt party can reject the executory contract, use the bankruptcy case to get out of it, which would make the franchisor a creditor in the bankruptcy case for whatever the lost revenue would be. If it's a solvent bankruptcy estate paying 100% to creditors, that could be expensive, but most bankruptcy cases are not, because if a debtor is going to pay 100% to creditors, chances are they wouldn't be in bankruptcy anyway, although it does happen. So the hotel owner who's a franchisee has the option of continuing the franchise arrangement or concluding the franchise arrangement, or can use the bankruptcy to say that they're going to terminate the franchise agreement unless it's renegotiated on more favorable terms.
And Joe, if they terminate, if they reject the agreement, what happens to the liquidated damages that may be there in that event?
That becomes,
is it clear?
Yeah, that becomes a general unsecured claim in the bankruptcy case. Most hotel bankruptcies have secured debt, where the bank that gave a mortgage, for instance, and maybe lenders on fixtures are secured creditors, and then the unsecured creditors, which would be trade creditors, food vendors, taxing authorities, employee wages, etc. And the franchisor would be in that category. And another analogous creditor would be if the hotel, say, has a fixture package on a lease, that could also be rejected like the franchise agreement and would become an unsecured creditor, where after the senior secured creditors and the administrative expenses of the bankruptcy case get paid, anything left would go to that class of general unsecured creditors for pro rata payment.
Okay, thank you very much.
Very well.
Any other questions from anyone?
Well, I thought that was very informative. I learned a couple things here today myself. So
I'm with you, Joe. I thought it was very informative. We are very fortunate to have the guest that we had, Joe Fields. We certainly appreciate your input. And Richard Saltzman, we also appreciate yours with all of the franchise agreements. I think we all learned from both sides, from bankruptcy and also from the franchising side, how important it is to make sure we go through all the legal background of the hotel and the contracts that are signed and will be signed in the future. So I appreciate having both of our guests, and also Joe Kennedy with Crystal Investment in Oregon. And sort of wrapping up our webcast for today, I'd like everyone to, again, first I'd like to thank you all for joining us and participating in the webcast. Don't forget to rate our webcast by clicking on the gray bar at the very top and the web player and give us an idea of how we did. Also, you can download a PDF of some of the listings that you may have saw on your screen today. Listings, section of hotel investment assets listed by hotel brokers under the attachment button that's also on your webcast player. As a reminder, this and previous Hotel Investor Markets website, webcasts are on our website, and they are on demand, so you can go back and look at them, and you can actually go back and look at this one. One of the good things is that anybody that wants to maybe review some of the things that both of our attorneys were able to talk about and give advice on, you can go back at those things and use those again. So please go back and do that. Just as a special reminder, we have coming up in September another webcast. Rochelle Stone, who is the president and founder of Starker Services, she's one of the partners, will be joining us to discuss all of our 1031 exchange questions and giving us some maybe new laws and some new things. Always an interesting guest to have. So I want to thank everybody for attending our webcast and for participating, and I certainly look forward to seeing everybody in September again on another one, and hope you all have a good day, and we'll talk to you very soon. Thank you again.
thanks, Tony.
Thank you.
Thank you.